appellant may reserve up to 5 minutes for rebuttal. Do you know how long you'd like to reserve?
2 minutes, Your Honor.
Thank you. I will make a note of that now. Up there on your left is the time for everyone. In your case, I will try to let you know there's about a minute left in your time, and say when you get to about a minute left in your time, appellee let you know I run out of time to give you that warning. And then I'll likely be keeping your rebuttal time up on that top circle rather than bottom, just so you know that
Okay.
if you're looking during the moment. Arguments are being recorded. So when you come up to make your presentation, state your name, stay behind the podium because we're visually recording you as well as audio recording you. We need to be able to see and hear you. You should not use the name of any child, minor, or victim during your argument. We do have some victims I know that talk to trial court. That might be the only folks. Please use initials or some other way to designate them rather than using their active name in this case. With that, we read your brief and are ready for you whenever you are.
Good morning, Your Honors. May it please the Court. Joseph Michelle from Summit Legal Defenders on behalf of the appellant, Cline II. I'll reserve 2 minutes for rebuttal, Your Honor. Trial courts cannot deny an expungement application unless it finds that the applicant's interest in expungement is outweighed by a legitimate government need to maintain those records. Here, the trial court made no such finding, and the record supports no such finding. Yet it denied Mr. Kline's expungement application for his 2004 assault conviction anyway. That is legal error, and the court should reverse. This is not the first time that the court has encountered this situation. This has come up a number of times, cited a bunch of cases in the briefs. I think the two that are closest to this one are State v. Wyatt, 2011, and then what I've referred to in the brief is NC3. There's a bunch of in-re NC cases, but the most recent one from 2022. And all indicate that when, particularly Wyatt, indicates that when there is nothing to weigh on the government side, then sort of obviously the government has no legitimate need and nothing can't outweigh something, so that it can't outweigh Mr. Kline's interest in expungement. And when you look through the record here, there is nothing in the trial court's decision that suggests that, that it weighed the government's interest or that there was a government interest. The trial court's analysis in full says, I've considered the application, I've considered the severity of the harm and the victim's statement, and the application is not well taken. That's not what the statute requires. It requires a determination that there is no legitimate government need that outweighs Mr. Kline's interest, and without that...
Is your position that there has to be a specific finding regarding that in the record for us to affirm the decision, or can we make that decision based upon our review of the record and evidence before the court?
So the court's jurisprudence suggests that there needs to be an express determination of that finding. But even if the court were to say, well, it would be enough if we could see in the record that the court said something like, government, I see your legitimate interest, I've considered that, I've also considered the applicant's application, and I don't think that, on balance, I think the government's interest is greater. If it were something to that effect, maybe, right? I think that's not consistent, though, with what the court has said before. But even if that were the case, there's nothing like that here. I don't think government interest, government need, none of that comes up.
The trial court judge seemed to be concerned that the defendant in this particular case wasn't expressing that he was rehabilitated by saying this was self-defense and these type of factors that led him to believe that there was not rehabilitation here. Would the fact that the court's required to find rehabilitation, would that go to the government's interest in your view of preserving the record? If someone wasn't rehabilitated, where would that fit?
So the government's interest in maintaining the records and Mr. Kline's rehabilitation, I think, are two separate findings the trial court has to make. They're delineated by statute in 2953-32, right, in D1 and in D2. That statute lays out a bunch of different determinations the trial court has to make, and those are separate things here. I know the trial court was worried at the beginning of its colloquy with Mr. Cline about the self-defense claim. Once Mr. Cline was able to explain further what he meant by self-defense and sort of that somebody else had attacked him first and then I think he still apologized though for what he did to Mr. Cline. I don't think his claim was that he attacked Mr. Cline in self-defense. It was sort of that he got involved in this fracas in 2004 as a matter of sort of being attacked first or something like that. But, those particular facts, I don't think the court needs to really get into that. We had 3 expungement applications that were heard at the same time here, and the statute speaks to the rehabilitation of the offender. It's not offense specific, it's applicant specific. And the court granted that the other 2 expungement applications, that it heard at the same time as this 2004 one, it couldn't have granted those unless it found that Mr. Cline had been rehabilitated.
Well, there's 3 separate cases. I mean, if the court looked at that and the first 2, the defendant said, yes, I was wrong, I shouldn't have done this, I apologize. And then the third case said, no, I'm glad I did it, I'm happy I did it, and that guy had it coming. In that case, you certainly could say some potential at some point to say, you know what, you rehabilitated on A and B, but now on C. I mean, do you automatically have to, once I rehabilitated one, you just have to find rehabilitated all 3? That seems to be what you suggest.
I think in a case like this, I think that's right, because we've got, the statute speaks to the rehabilitation of the offender and to the trial court's satisfaction. It's the same trial court judge hearing all 3 of these things at the same time, it's the same offender. It would be difficult for the trial court to find that in this middle case, that Mr. Cline has somehow not been rehabilitated yet. And I think the record belies that determination anyway. What the trial court said is that I am making a finding that you've lived a very different life since your last conviction, the most recent one that was at issue in this case was 2006, right? And so there is evidence in the record, right, that Mr. Cline is involved with his son's youth activities at their church, that he's a good father, that he has had no criminal charges really of any kind since 2010, and that was just a minor misdemeanor. And so the court's finding on page 18 of the transcript that he finds that Mr. Cline has lived a vastly different life than before does suggest that the trial court found that he had been rehabilitated. I know that the city has argued that, well, it's a little unclear to me actually, whether it argues that there was a finding that he hadn't been rehabilitated or that there wasn't a finding of rehabilitation at all. First and foremost, the city did not raise any of those objections in a written objection to the court or at the hearing. I don't think Mr. Cline's rehabilitation was really an issue at all once, aside from the trial court's initial trepidation, Judge Stevenson, to your question earlier, about Mr. Cline initially saying something about self-defense, and I think that got cleared up though as it went on. But because the statute speaks to rehabilitation of the offender to the trial court's satisfaction, I think it's possible that there could be, that had Mr. Cline applied for expungement in 2 different courts for things that happened at 2 different times, then I think it's possible that you could have one trial court judge saying, I'm finding that he hasn't been rehabilitated to my satisfaction, right? I don't think that would control the rehabilitation finding of another judge, but when you've got the same judge talking about the same offender, hearing these cases at the same time, I think the statute speaks to the rehabilitation of the offender specifically, not the offense.
The court in the oral hearing said that the court considered both the application and the victim statement and found the application not be well taken. Where does the victim statement come in your view of this as being a two-way, 2 things, 2 way? Where does the victim statement come in?
So it comes in I think, one place specifically, certainly under D1, Section D1 of the statute, the trial court is required to consider a victim's statement or a victim's objection. I think that's effectuating Marcy's law there. I'll note as a factual matter, the victim did not object here. The victim, RF, authorized his sister to speak on his behalf. His sister, I think, went out of her way to say that the victim forgave Mr. Cline, did not have any ill will towards him, didn't have anything to say, right? And the victim didn't make a separate statement. It was the victim's sister who said, I don't.
Let me just ask, there was a victim impact statement, I thought, from the record. Was that by the sister or by the actual victim?
By the sister. There was a written statement from the victim that says, I authorize my sister to speak on my behalf. The letter that's in the record is from the sister as well. And that's, I think, largely echoed in the testimony at the hearing. It's the same thing. So I think, sure, yes, the trial court has to consider that. It can't say, victim, I see you in the courtroom, I'm not going to hear from you. That would be, I think, a violation under D1. Under D2, though, there's nothing, there's no requirement that the trial court weigh that statement against anything. What what is required under D2, right, so the trial court makes findings that Mr. Cline was eligible, that he has no pending charges against him, that he's been rehabilitated to the court's satisfaction, and that the trial court determined that his interest in expungement is not outweighed by any legitimate government need, and that's it. If it makes those findings, it has to grant expungement. It shall grant expungement, is what the statute says. Now, had the legislature wanted the victim's statement to be weighed as part of that, it could have carried that language over from D1 to D2, but
So
it didn't.
despite, your view would be despite the fact that the court said, the statute said you have to consider the victim's impact statement, under what the court has to consider, it has no bearing whatsoever.
I think it has no bearing in the weighing, that's right, and especially in this case when the victim did not make a statement, right? We have the victim's sister who's saying, I don't forgive Mr. Cline, I don't think he deserves expungement, but goes out of her way to say that the victim does not share those objections, and there is no separate objection from the victim. So the victim's sister is not a victim of the crime, that's not in dispute, and mostly what she says anyway. I think let's assume that we could count what the victim says, especially in a case like this where the government says, well, we stand by, right, the government's entire position is I stand by the victim's statement here. So let's assume that the government could adopt the victim's statement as its legitimate government need. Nothing that the victim's sister said in this case would qualify as a legitimate government need under this court's jurisprudence.
Would it go toward the first aspect of whether the application should be granted because he's not rehabilitated?
No, because those are separate findings. So I think breaking those things out, right, and I think this is why a lot of the courts, including this one, when they've looked at whether the severity of the offense or the nature and circumstances of the offense, whether that can be a legitimate government need or whether that can be a reason to deny the application. I think the reason those courts have said no, that that's not enough, is because the first criteria is whether this particular offense is eligible for expungement in the first place. So I think because we've got all these different statutory findings, and the trial court has to make each one of those things separately, I think that speaks that there's not really overlap between those things. It can't be that the government's legitimate need is, well, we don't think this offense should be expunged because that's covered.
Counsel, so just so I understand, are you suggesting that the government doesn't have a legitimate government interest that an offender is rehabilitated?
I mean, I think it has a general interest in that, but I think the statute rules out that would constitute a legitimate government need to keep the records open. I think what that's speaking to is, given all of those other things, let's assume, right, assuming that the offense is eligible, that there are no pending charges against this person, and that the person has been rehabilitated to the court's satisfaction, there could still be a legitimate government reason for keeping those records open. I'm thinking particularly in maybe some public official, some sort of embezzlement crime, or right, some sort of crime that betrays the public trust. And if that person were to run for office again or to hold a position of power, I think there's some examples in the case law, right, of people who had positions of power in, I think, particularly a prison, committed crimes and then moved for expungement. All those other criteria were satisfied, but the government said, hey, the way that this is something that the public needs to know about, this kind of abuse of power, this kind of betrayal of the public trust. So the legitimate government need for keeping those records open has to be, I think, different from those other statutory criteria. I think otherwise it's difficult to understand why the legislature would have broken them out so separately and required the trial court to make those findings expressly, each one of those separate findings.
You don't want to interrupt your answer, but you're now about 20 seconds left in your initial time.
Thank you, Your Honor. The last thing that I'll touch on before my rebuttal point is, I think the argument that there was no, I just want to talk about the argument that there's no evidence presented because nobody got sworn in or there wasn't evidence submitted, I think is foreclosed by Supreme Court of Ohio precedent, particularly in State versus Hamilton, State versus Simon. Hamilton in particular dealt with sort of the inverse situation where the defendant said, hey, court, you can't take what the prosecutor argued as a reason for denying my expungement application, and the Supreme Court of Ohio said, no, that's not what we're doing here. This process is not adversarial, it's about information gathering. It's why the statute requires a probation department report, really, and that almost never gets entered into evidence. So I think that That argument just misunderstands the nature of expungement proceedings and the general and very relaxed rules of quote-unquote evidence that apply to those proceedings. So if the court doesn't have any further questions, I'll reserve the remainder of my time for rebuttal. Thank you.
May it please the court. My name is Ian McCarthy. I'm a certified legal intern representing the state of Ohio in this matter. I'm here to explain today that the trial court in this instance did not abuse its discretion. Mr. Cline's application for expungement in this matter was denied by a failure to show that he was rehabilitated. This decision did not come arbitrarily by the court, founded on statements that Mr. Cline made during this proceeding, which we will get into. No evidence suggesting the contrary, that he was rehabilitated or presented to the trial court, all of which were weighed to find that Mr. Cline failed to meet his showing that he was effectively rehabilitated for expungement purposes. You have heard a bit about this self-defense comment. I want to reiterate that this comment was made after it was requested by Mr. Cline, or to Mr. Cline by the trial court, that there was a written statement, and if he wanted to offer any words of apology or offer any words of contrition, effectively being able to show that he had been rehabilitated and would be able to satisfy the requirements of that third element. And that's when he immediately gets into the self-defense claim, essentially passing the buck of some responsibility without accepting all of it. The trial court correctly took this instant, questioned Mr. Cline further on this statement, and ultimately determined that he was not rehabilitated to the court's satisfaction. Again, really with that statement, his failure to show, no evidence to the contrary, some of the severity, the lasting impact, all of these things were considered to make a non-arbitrary refusal in his decision of this appeal, or of this expungement proceeding here.
The court has questions about rehabilitation, but does the court ever, either on the record or in their written decision, find that he was not rehabilitated?
I believe it was determined that not to the court's satisfaction, no.
And where did that come in? You have the defendant arguing in this case, we're supposed to look at two things in essence. The state's right and interest in keeping the record and his right to have a record expunged. Where did the question of rehabilitation, if you, A, do you agree that's what we have to look at, as the appellant suggested, and where would rehabilitation fall into that?
Rehabilitation does serve as a legitimate government interest, and the other aspect of this is the state bears no burden in this kind of hearing as far as articulating or effectively showing one. All burden in this matter falls on the applicant to show otherwise or show to the contrary. We just happen to have this, which we wish to present as furthering the argument that the court made the effective or the correct decision here.
And where does the victim statement fall in? How does the court get to consider the victim statement? In the court's interest in keeping the record preserved, if they find the victim statement is enough to raise the level of not expunging?
Could you clarify and rephrase the question?
Well, we have this question of the victim has the right to make a statement.
Sure.
And Judge oral statement, Lee said, based upon the victim's statement, I'm not going to expunge. Where does that fall in the statutory equation? Why does the court get to consider the victim?
I believe the victim statement could be considered. I don't believe it's the only means or the sole factor as far as refusing this decision. I think it's something that was considered by the court. Again, the response by Mr. Cline after being made aware of the victim statement there suggested that he acted in self-defense. I think that coupled with that admission falls into that equation there. Again, with everything apparent here and considered properly, I want to state again, this was not an arbitrary decision. The court did come to the correct conclusion. This was not an abuse of discretion, and the state asked this court to affirm that decision.
I have four quick points here on the phone. I think think, Your Honors, you can search the record high and low, you're not going to find a factual determination that Mr. Cline was not rehabilitated. It simply does not appear anywhere in the trial court's written decision. It doesn't appear anywhere in the expungement hearing. What the trial court said on page 18 of the transcript is that I find that he has lived a vastly different life than he has before. Second, as far as the state having no burden, that is not true when it comes to the state articulating a legitimate government interest. If it has one, it has to assert it, and it has to do it at some point, and it did not do that in this case. So there's just nothing on that side of the equation for the trial court of this court to weigh. The third point, that considering the victim's statement, that is just one factor. As the 8th District explained in Ray KW, right, that while there's not a lot of guidance on what kind of weight should be placed on this, it is just one factor in the analysis, and it doesn't change the fact that the statute expressly requires the trial court to weigh a legitimate government need against the applicant's interest in having the expungement, in having the records expunged. And fourth,
I know your time is up, if you would briefly conclude.
Sure. For these, I have just one last point. That,
Briefly conclude, if you would.
we would just ask because there was no express determination that Mr. Cline's interest was outweighed by the government's legitimate need as required by the statute, we ask the court to reverse, or at minimum remand for the application of the statute. Thank you, Your Honors.
Thank you. The court will take the matter under advisement and issue a decision in due course. The clerk of court will mail a copy of that decision to you on the date of release. It will also be available on the High Supreme Court website. With that, on behalf of the court, I'd like to thank both of you for your presentation this morning.